Thank you all for being here today. I'm not used to sitting in this chair. So we are coming together for the subcommittee on House Bill 553. We want to respect all of the work that was done by Senator Carson and her committee over last summer and fall, along with a lot of our advocates. And we do think that they did a very thorough job, but some questions, some worries have come up. So we just want to make sure that we have all of those kind of fleshed out so that way people can understand where it's coming from, how this law would impact, or how this change in 169C would actually impact the state and families in the state. I also want to start out by saying that on House Bill 553, this is not a punishment thing or anything. This is literally the definitions of child abuse and neglect and the rebuttable presumption of harm in abuse and neglect case. So this is really the foundation of how we then build other bills as far as what we do with this information. But for us, this would be a definition of what abuse is. So I will leave it to any of the committee members if you have a subject you'd like to bring up first. I know that we have had quite a few questions. Yes, Representative DeSimone.
Thank you, Madam Chair. There was a question of the constitutionality of this bill. I checked the Constitution, and in my opinion, there is no data showing that this is unconstitutional. And further, I went into the system, and there are a multitude of cases, one being Troxel v. Troxel, where the Supreme Court felt that this particular bill and the definitions of which don't seem to fit the criteria for being unconstitutional either. And I just wanted to set that tone before we move on with this important work.
Thank you. I appreciate it. There has been a lot of question on that. And certainly, I think that is, once again, when we have extensions of this bill, what we do as far as quote unquote punishments or actions and stuff that is not a part of the definitions of this. Does anybody else have a concern that they'd like to bring up? Thank you for your work on that. Or any concerns that you've heard. So one of the things that we did, we had some testimony on was actually our trauma-informed language when it comes to somebody who has a substance abuse disorder. And so I did actually look at trauma-informed language. So here's what we have. And then I have supplied this to the Office of Child Advocate. So the more trauma-informed language and then why the changes, so we can take a look at that. That could be a possible amendment. I also do want to bring to light that I think a lot of the concerns that we had before were based on how 553 came out of OLS, which was not the intended way that it came out. So we did have that, the amendment, yeah, which, what is that number?
553.
Yeah.
The amendment is, 114.
114.
114. So anyway, and that replaces that language back to what the study committee had and that we refined last fall.
Yep.
So if everybody wants to look at the trauma-informed language, does anybody in the audience want to see what the trauma-informed language is and why? Got some extra copies. And this is just around concerns of mothers who have substance abuse disorder and their child is born. Does this, flag them to have their children removed immediately? It does not. It just, we understand that children who are born with substances have tendency to have certain complications, and we want to make sure that that's known, that that's not best practice for children. Does everybody agree with that? Okay.
So does someone want to get an amendment to
So
change that language?
yes. Would you guys like to vote on that language, or do we have to vote? What do we do?
Well,
Or we just have to do an amendment?
yeah.
So I agree that we need to do that, but I think that there may be further changes to the current amendment before we send to any
Right.
language to OLS, and I'd like it to be one, I personally would like it to be one clean amendment. So I absolutely agree that this should go into the amendment, but we not send anything to OLS until we're done.
I agree. And we haven't voted on the other amendment that we brought in, so we could actually redo and have one seamless amendment, correct? Okay, so we could do that.
Yeah.
Okay,
Excuse me 1 second. I have a question for the.
absolutely. Okay. So, well, she has, do you want me to wait to continue at all? Okay. So I think one of the larger questions that we had, and this was on, and I know there's some people here that can testify who are doing groundwork on this particular thing, is the emotional abuse side of it, and whether or not somebody could, let's say, get in trouble for grounding their child for, not having their car, or say the child comes out as gay or something, and then that's disagreed upon. Would that be, grounds for a child for being abused? And my understanding has always been that a disagreement is a disagreement. It's how far you take it, that whether or not it takes it. Do we have somebody in the audience that has done groundwork recently or can talk to us about what DCYF would, if there would be an intervention or what would happen in that case?
Good morning, Jen Ross, Deputy Director, DCYF.
Thank you.
Can you ask your question again, Representative Gregg?
Yes. So one of the concerns that we had is basically on the emotional abuse side and what that entails, like whether or not a parent disagreeing with the child's gender, or a parent disagreeing about whether or not a child has certain friends, or how that impacts, how that would fall into that. Would that be a concern with the way that the language is now written on 553, having emotional and psychological abuse? Or what, if that was called in, let's say, what you would look at for that?
It would not make any changes to what we would currently do. When we think about psychological abuse and when we're looking at the information that's being reported, whether to screen in or screen out, we're looking at a couple of different things. One is the nature of the allegation. We're looking at, is it something that is likely to cause, or the child is likely to suffer serious psychological, emotional harm as a result of the parent's behaviors, their actions or inactions. And we're looking at things such as persistent and severe, like ridiculing, terrorizing, bullying, isolating. We're looking at ongoing, yeah, certainly, yep. So this is right from our own policy. So psychological abuse is defined as reports where a child suffers or is likely to suffer psychological, emotional harm as a result of parental behaviors. It considers both the caregiver's actions and inactions, as well as the impact to the child. So actions that are reasonably expected to produce significant adverse impact on a child's emotional well-being could be examples like persistent and severe ridiculing, terrorizing, bullying, or isolating of a child. It could be threatening specific physical harm to themselves, a family member, or the pets, persistent non-specific threats of self-harm, or a caregiver overdose in front of the child. So those are sort of what we're thinking of when we're looking at psychological emotional abuse. Yes.
I see that you're reading that policy. Is it possible for that to be forwarded to us in some way?
Yep. Yeah.
I can't.
Yeah, I'm sorry.
And this is
Yeah.
so crucial. I don't want to miss anything.
Yes.
It truly is crucial,
Yeah.
I believe, to the bill.
Yes. Yep.
Thank you.
And then we're looking at what is the impact to the child. Does the child have ongoing indicators of emotional disturbance or emotional abuse, which would be bedwetting, anger issues, psychological, emotional concerns, depression, anxiety, severe withdrawal, extreme or persistent behavior, or running away or self-harming. And so really it's the twofold. It's what is the action or inaction of the caregiver, and then what is the result of that action or inaction to the child. And so certainly I think when you're being asked about whether or not taking away car keys or grounding a child or taking away their cell phone is what we would consider to be that prudent parenting. You're doing it for a reason of concern. Either they're contacting, someone that they shouldn't be contacting, to Representative Gregg's example, or you're trying to prevent them from harming themselves or harming others. That's the prudent parenting that one would expect a parent would do to take those actions if there was concern.
Thank you. Thank you for taking my question. There has been, there have been statements bantered about that people are afraid to be on board with this bill because they're afraid that parents will say, go clean your room and don't come out of your room until it's cleaned up, that would be considered parental abuse. Can you speak a little bit about that? Thank you.
Yeah, exactly. So if we were to receive a call on that, it would not be something that would be screened in, because again, it's prudent parenting, a parent exercising their right to ask their child to go clean their room and don't come out until it's clean. Again, what we would be looking for is some more of those extreme actions of a parent where they're perhaps locking their child in their room for days until the room is cleaned or something like that. So a simple request by a parent for a child to go do something is not in and of itself emotional abuse or neglect.
Thank you for being here. Thanks for taking my
thank you.
question. So I know that one of the concerns that people are having are, what if a parent denies gender affirming care to their child because they don't believe that that is necessary, believes they're too young, believes anything. How are we going to protect those parents? Because this is going to be a problem to get this passed.
So if a parent is again acting within their right as a parent and it's prudent parenting, that is I think for me, it's a little bit more of a difficult what if to say that there'd be one thing or another. I think we would have to look at the whole picture of that. So what is the outcome of that for the young person? And are they, what is the conversation that the parent is having with the young person around the gender affirming care or their disagreement with that action for their youth? We would want to know how is that impacting the youth and or the child themselves. It's a hard question to answer either way. I think there's a lot of things. What we would be looking at again is that's a parent's right to exercise that particular right for themselves and their youth. But again, the bigger picture, like, is it causing the youth severe emotional discomfort? Yeah, I don't know, Susan, if you want to help me with the legal.
So in that, so if you got a call, that would not be screened out?
Well, so if we got a call and it was simply that they were not allowing their child to do that, no, it would probably be screened out.
I don't know if probably is a strong enough.
Yeah.
I don't know if that's a strong enough word. To,
Yeah.
I'm concerned.
Yeah. So again, we would be looking at if a child had diabetes and needed medical care and the parent was withholding that medical care from their child, that would, and that's a life altering, a life-threatening disability, that would be a report in of neglect from the parent for their inability to provide their child the correct or needed medical care. Gender affirming care is not, in my opinion, is not a necessary medical care for the child that they would need. So a parent would have the right to not consent to that care for their child. And it wouldn't be screened in under neglect. So what we're looking for is what is the outcome to the child. So that wouldn't necessarily be neglect for the child because it's not a necessary medical care for them.
Is it more how so this is not in itself denying the gender care would not be an issue. It's how the parent handles it after that. So it's one thing to tell your kid, no, I disagree. It's another thing to start getting, verbally, emotionally, maybe physically abusive about how you have that conversation. And that's why it might lead to something besides screening it out. Is that kind of what you're saying?
Yes, yeah, yes. It depends on how the parent then goes about handling it, and it depends on what's happening for the youth. And so, if because the parent and youth have a disagreement with, what's to happen, the youth wants the gender affirming care, the parent doesn't want it. The youth then becomes angry, upset, suicidal, and needs additional mental health care as a result of that. We would expect the parent to meet the needs of that additional mental health care, and if they're not doing that, then that could potentially be neglect. Or, like you said, Representative Gregg, the other side is how is the parent handling that request of their youth if they disagree with that? And so then do they start calling them names, or are they, prohibiting them from, like, let's say they want to wear certain clothes, and it becomes a greater issue where the parent is now persistently, negatively communicating with their child about their wishes or their wants. And it becomes then a bigger issue. Yeah.
Thank you, Representative Gregg. Thank you for taking my question. Do you have in policy for screeners to have the same approach to this topic that you do?
We do, yes, we do have policy for screening. All of our screeners look at the policy to determine what is the information they're receiving, where does it fall within our policy pertaining to neglect or abuse, and then they start to weed out the specifics, and then they look at, this, then this, then this. So there is some consistent decision making. Is it in there specifically around gender affirming care? No, we don't have anything specific to that.
Can I follow up? Oh, yeah. Would you be able to do that?
I'm uncertain if we would want to start breaking out different types of needs that families have. We keep it broad for a reason. And so if we were to add gender affirming care, would we then have to add something else, or in addition to gender affirming care, that could become a challenge for families to navigate through?
I know that's an important topic for a lot of people, and I do understand. And once again, I think when we're looking at definitions of emotional, it's not just disagreeing with the child. It's really like where you take that. That's what emotional and psychological. So I think that's really the kind of crux of the entire thing, that it's not about saying, gosh, I mean, if we're talking about gender affirming care, even though, yes, that's very impactful, we could also talk about piercing ears or, other things that kids, religion.
Yep.
So I see how hard that would be to start separating things out, to specify for each individual thing. Certainly religion is a big topic, one that I even had with my own children, where we differ, and that's part of them becoming, who we are raising. So thank you for that. Does anybody else have any questions for her on that? Okay, did you have something legally that you wanted to talk about, Susan, with that, or? Okay, come on up.
I could see her jumping.
Yes, I know.
Good morning. Thank you for having me. Susan Larrabee, General Counsel for DCYF. Again, I just wanted to reiterate that over the last decades, the legislature, all of us have been doing a lot of work based on what we've learned about being trauma informed. And back in 2021, I think I mentioned this at a previous hearing, back in 2021, the legislature added House Bill 1573 to the statute, which finally defined psychological maltreatment. And as Deputy Director Ross just pointed to our policy, that policy and procedure was written in response to finally defining psychological maltreatment, which we all as society know that is the most common form of abuse and neglect in our country, probably the world, if you look at statistics. And so back in 2021, the legislature, you all, added psychological maltreatment finally to the definitions. That psychological maltreatment means pervasive and emotionally abusive behavior, which shall include, but not be limited to, patterns of threatening, berating, or demeaning behavior. And Representative Gregg, as you mentioned, it's not necessarily the reason why they are berating the child or belittling the child. It's the belittling and the berating and the patterns of threatening behavior. That's the neglect of a child. I hope that makes sense. And again, the context of it all. So there is really no change to the definitions of neglect, right? The definition of neglect, that you have a parent who is, or child, sorry, a neglected child who is without the proper parental care or control, and education is required by law, or other care or control, and there is that serious risk of impairment, that harm. And we're just fine tuning. What is that harm? That's really hard to define. It's very nebulous. And what has been done over the course of many, many months and now years is relooking at these definitions as they are. So the average person, when they're reading the statute, understand what it means. Because serious impairment, risk of serious impairment, that's a mouthful. It then points you to another section of the statute saying, okay, let's define serious impairment. Serious impairment means a substantial weakening or diminishment of a child's emotional, physical, or mental health, or of a child's safety and well-being. Again, that's already in the statute. It's just very hard to understand. So again, what's being done here and throughout many efforts and a collaborative effort is to make it more user-friendly, that the average reader is going to read this statute and understand what's expected of our community when it comes to reporting suspicions of abuse and neglect.
Thank you. What statute are you referring?
Sure, I'm looking at the definition section, 169C3. And for the definition of psychological maltreatment, and the definitions are in alphabetical order. So we are up to, yes, 25A. I know I had to do my Roman numeral conversion.
That's what I thought. I appreciate it. I just want to be sure that my notes are
Sure.
correct. Thank you.
Okay, thank you.
Representative Gregg, I received an email from Representative Markell concerning a concise analysis of the proposed amendment. I'd like to pass it out. And I haven't, I have enough. If anybody in the audience would like to see it, I have a copy that I can share.
And we'll just take a minute to look this over.
I think he makes some good points.
Can you tell me the qualifications for the CPSWs and as far as it pertains to psychological abuse? Also, yeah, I just want to know how they're trained in that. That appears to be one of Attorney Markell's concerns. And trust me, I have a daughter who's a social worker, so I already know the answer, but go ahead.
Good morning, Jen Ross, Deputy Director. So to your question of the qualifications of a CPSW, they're broad. We can take anyone with an education in human services, social work, psychology, education. We look for a background in working with children, youth, and families to bring that work into ours. But we certainly will, we will work with anyone who has that education component, even if they lack an extensive history. They then go through what we call a core academy, which is a 12-week educational component for our staff that really goes over our policies, procedural work with families, engaging families, and understanding sort of what it is to be a CPSW and what does that role look like. There's a component of going through the law and the statute with them. There's a component of going through investigations and casework with families and how to engage them. So we really focus on the engagement with families to understand what is the challenges that brought your family to our attention, and then how can we work together. So there isn't a specific focus, if you will, on psychological or emotional well-being. It's really looking at the family as the whole scope. We do have staff attorneys that we then work with to determine what is the information that I've collected. These are the concerns, and what fits the scope of the law or doesn't fit the scope of the law. And supervision, and so it's really a team approach to the information that we're gathering, and then what does that mean in terms of how we might become involved or not become involved, or what does the family need in addition to that for referrals or resources. I don't know if that answers your question.
So, I guess my, how do I want to phrase this? So if it is a case of psychological abuse, you have the ability to offer resources to these families, especially for, say, a psychiatrist or a counselor or things like that, correct?
Yes.
Okay, thank you.
Yep.
I don't know if any of who would be the right person to answer this question, but in looking at Representative Markell's suggestions and stuff, this looks more like, to me, the process that would be litigated after DCYF has initial findings, where the bill we're talking about is actually just definitions. So I'm actually concerned that he's taking it that bit farther. This is not about definitions, what I see, unless I'm understanding this wrong.
I have to agree. I think he's thinking about afterwards. This is strictly definitions.
Right.
It's not structuring a policy, procedures.
Can you turn your mic on?
It's not structuring policies or procedures. It's strictly definitions as a guideline. So I too don't feel that this stuff is necessary to change anything in here.
Yeah, I think he makes points for after the fact, but not about this particular bill. Yes, Liz Damasio. I think she's got input.
I was going to say, to your point, exactly, Representative Gregg, that this is information that we would do post-filing or even before filing if we were working with a family on a voluntary basis, is really allowing for these assessments to occur to help us have a better understanding of what are the needs of the child, the youth, or the family, and then what are the appropriate referrals for them. So exactly, this would be our casework after filing or when we open a case to work with a family.
Hi, Liz Damasio, Associate Child Advocate. We're sharing all one copy here, but I just wanted to reiterate too that the basis of this bill, it did come before the legislature last session in tandem with SB 417, which was written very specifically around placement preferences. And this bill, the sort of purpose section and 417 really focuses on the fact that preserving the unity of the family is the primary purpose, maintaining the family unity. So this is not meant to take children away from parents which 417 says very clearly that's already been signed into law, and this purpose section very clearly. Again, there's even a change in language here that says instead of determining the best interests of the child, it is determined already that the best interest is to remain with family. So again, I think you all keep hitting on the point here that these are the definitions that allow the agency to get involved, to provide services to help that family maintain their integrity. One of the precursors too was that there were times though where the agency was trying to get involved, had filed a petition even for an in-home case, which means the family children not get removed, and the courts were interpreting neglect, interpreting serious impairment in a way that was leading to results that babies with 9 broken bones were getting sent right back to caregivers without any services or safety plans in place. So it was sort of that gap that was trying to be filled and continues trying to be filled. The goal is not to take a bunch of children away from parents who want to make them clean their rooms. It really was filling these specific gaps that the agency was seeing. So I just wanted to kind of, Jen's doing a great job. I just wanted to bring that up again.
Thank you. I just want to let you know that at the last DCYF meeting, of which I'm on the board, this is exactly what I was talking about, is where is and I asked the question, where is the gap? What does the legislature need to do to fill that gap so that the job can be done well? And I think that's what you're just pointing out to us, and I appreciate that.
And that's why we worked so closely this fall. We had 8 sessions, most of them 2 hours long, in front of Senator Carson, Senator Whitley, Representative McMahon was there as well, and Representative Robert Harb, talking through every word in here, every amendment, what the purpose was, what the outcome would be, and really thoughtfully collaborating of, you know, what would be the impact of changing this word, that word. And as Attorney Larrabee said, some of these changes were made and policies have been put into place, but the court is still not quite reading it the same way. Particularly, I think the addition of the definition of trauma informed was super helpful. And that was at the request of Senator Carson and Representative McMahon. We all say that all the time, like we know what it means. But again, I think Attorney Larrabee is correct that a lot of the nuances here are not a change, but make it a lot more transparent for parents to know what truly is abuse or neglect.
So I think to talk a little bit about Representative Markell's email, I think what he's trying to do is understand what the bill and the amendment say, and then try to educate us on what would happen if it goes to court. Not that we need to change everything in the bill, but I think that's where his brain's going. So I agree with you that this is going to be the aftermath
Well,
of
and
this.
yeah, and I think that I appreciate that he's of that mind and that we have him on our committee now to kind of help us work through that stuff. But with that comes, you don't have that kind of, you know, when we go through the steps of legislation, as far as I understand, I'm still fairly new, but is that when we have the definitions, this is literally the root of this, of protecting kids. And what he's talking about is something that builds on after. So maybe there's something in legislation that comes from this, but this at least defines it. And that's my understanding. So I think he's got a valid point, but I just don't think it belongs in here. Then all of a sudden it's not just definitions.
Right. And I think too, from what I've skimmed, it would be several steps. Like Attorney Larrabee said, when the law changed in 2021, legislature did a definition. It was 2 sentences long. The division then works on creating new policies, new standard operating procedures. That then goes into their core training. It goes into attorney training. So I think you're right that this definitions is the first step, and then you need to let it play out a bit. Let the division do their work. The OCA does have oversight. We work with them very closely on developing policies. And you'd have to let it play out again and see like the policies and trainings that happened.
Right.
if I may. So what I'm getting from this is just providing clarity and transparency, especially for parents too, right? There's nothing in here that says we're taking your children. This is just providing transparency and clarity of the definitions that are really already being put to work. And so I don't, other than the changes that with the trauma informed language, I don't see any problems with this bill. I think it was worked on intensely. I think that, anything that was not appropriate to be put in here, I trust was not. I know Senator Carson. And so that's where I am with this. I think that this is, with as amended, can only help parents, in my opinion.
Thank you. And thank you for taking my question. Should this bill become law, do you foresee any significant increases in the amount of cases that will happen, or this is not going to increase and it's just defining and better defining what is already in practice?
Thank you. Thank you for the question. I don't see it as increasing cases for the division. Like OCA Masio suggested, is that it's just some additional clarity for the division. And I think additional clarity for the courts. I think it will help us protect a certain population of children who I think we have struggled to protect, those being the youngest with those injuries that have been a challenge. We've worked together with the OCA to have discussions about those, which I think was some of the precipitous to prompt this legislation. It does allow us to work with families in the way we already are. And so I don't necessarily see it as a way for us to become further court involved with families.
Thank you. That's what I thought too. I wanted it on the record because I think that there are people who are very concerned about that. So I just wanted to have that on record.
And we worked very hard to bring this forward in a way that wasn't an expansion so much as a clarification. I believe the division has said throughout that there was no fiscal note as well. We did actually take out a section during that fall working section on institutional child abuse because the implementation of it would have been challenging. It may have created more cases. It was a little bit unclear. So we were very mindful about that through that whole working process in the fall.
Do you know how many states have language similar to this with the emotional in there?
I do not know the number of states, but I can tell you when the OCA was working on this language originally, which was in the fall of 2023, we had done sort of a survey of a number of other states on a number of different sections, looking at Colorado, Connecticut, New Jersey. Maybe there was like 5 or 6 that we were looking at to try and really hone in on the right terminology. And most of those, I think all of those ones were using emotional. They had sort of a different combination. So we sort of landed on the combination that made the most sense. But certainly ours was much narrower than many others at this point because ours was drafted 45 years ago and had not had sort of a large expansion of terminology.
And we hear about this more and more, and I think just for the record, it's important to understand why is it important to include emotional when we're talking about these definitions.
It's important because emotional abuse it's not, when we investigate or have an involvement with a family, it's sometimes not just one type of abuse or neglect that we see. That we know emotional abuse it happens far more frequently and can be just as traumatic for a child to experience. The old legislation was prohibitive of our ability to be able to recognize emotional and psychological abuse of children. We had to have a specialist to come in and testify to the fact that that was happening. This does allow us an ability to be more involved with families when they're struggling with, meeting their needs of their kids in a healthy way. That's not, emotionally or physically or damaging to their well-being. So I think it's important to have the psychological maltreatment component. We know it's pretty damaging to kids. Mm.
Is there any way that you can find out that for us, how many other states involve the emotional and psychological abuse in their definitions?
I actually have that
You
at
have it?
home, so I can
Okay.
tell you.
You okay with Jody's?
I'm okay.
Whoever wants to do the research.
Chair,
Yes.
don't we want to check out Representative Nelson's research and look at what we have here as a definition for the emotional abuse
Versus in other states?
versus what happens in other states, tried and true methods or whatever. I just think it really, emotional abuse is so difficult to define. I read, and I'll bet people out here have heard about the books. I've read David Pelzer's books. I don't know if you've ever read them. It's a powerful. If you want a good cry, but his first book was A Child Called It. They are absolutely horrifying. And I don't mind telling you that I am a survivor. I had one brother called A Bundle of Love, and myself, my younger brother, and my sister were called meatheads. I get it. I get how somebody would say, because of there was a series on TV about a very nasty man, and he called his son-in-law meathead, and people thought it was funny. It's not. It's just not. So I think it's important for us to get that component of this bill right. It's very difficult for a child to come forward and say how it hurts their hearts. And I've said this a million times. On my refrigerator, I always posted, when I was raising my kids, sticks and stones can break your bones, but words can break your heart. We can put casts on broken bones, and not to minimize that. And I'm not minimizing the physical abuse at all. We can put Band-Aids, we can put stitches, we can heal bones, but we forget about healing the heart. And I think that's one of the most important components of this bill is how do we help parents understand what words do to children?
I appreciate you sharing that, Representative DeSimone. I actually have a resource that I meant to send to you this morning, and I forgot. I will send it to you as soon as I get back to my office. I actually attended a really wonderful training for the new children's attorneys. You all passed SB 463 last year. About ACEs, the adverse childhood experiences. So that study originally dates back all the way to the early 90s. It is not controversial in any way, well accepted science. There were definitions of emotional abuse and emotional neglect in that original study. So I have a slide deck to share with you all that I think really does lay that foundation. It's not new. It is very old. It just hasn't Correct. So, but I think it would be really helpful because it really splits out sort of those adverse childhood experiences and the different types of abuse and neglect, which includes very specifically emotional. Give some examples. So I think it'd be helpful for you all, and also just in talking to your colleagues. So I will share that, and I apologize. It was on my list of things to do this morning.
It's a Monday.
Yes, it sure is.
Now that we are going to have one more subcommittee meeting, I think, after this in a couple weeks. Actually, it's going to end up in a few weeks because we have that week off. So anyway, we will have another one so we can talk more about that. Does anybody else have concerns for today that they'd like to flesh out? Go ahead.
Just some feedback that I've heard is that people are concerned about specifically what the definition is of that. And they're really stuck on if I send my kid to their room, are they going to call DCYF? So that is one thing that I wanted to bring up here today.
Yeah, and I think that's going to be important for us to have those conversations because there is a sense, and you get that anytime we talk about the definitions of child abuse and we start talking about the neglect, people get worried because of what happens after that. We did have in all openness, we had, a couple different groups wanting exceptions, and we heard that the other day, that this is abuse except for when. But ultimately, this is about the definitions of child abuse, period. What happens after that is very, very different. This gives no more right for people to take their kids away. As a matter of fact, this actually has language in here that strengthens as I want to call you just Lissa, as Lissa Masio from the OCA has said. But we do know, and it is in law, in statute in this state, that we think the family is the best place. So that's really the security blanket on this for families. This is about defining it so that we can get definitions. So people that maybe have patterns set up from their own, how they were raised or whatever, we can, they can step in and say, so that's not the best practice anymore. We understand that this is not great. And that's my understanding. Is that for you guys correct? Okay.
So I just want to be reassured you're going to send us the list. That's going to be very helpful.
I will. Yes. Yep.
Did you have something that you wanted to talk about? Okay. Well, congratulations early.
Thank you. And I hope the last one I had was 8 days late. And so I'm really praying that we don't go that long. So thank you very much. My name is Michelle Merritt. I'm the president at New Futures. My colleague, Emma Savini, testified during the hearing. And I did want to bring up an issue that New Futures had been working on. It's actually a legacy issue that was sort of brought back up in the context of reviewing this bill. In 2016, when we were in the height of the opiate epidemic, there was a bill very similar to this that was put forward that had some unintended consequences when it came to parental substance misuse and including it in the definition of neglect. We did a lot of work on this and ultimately settled in the area of creating a rebuttable presumption of harm that still exists within the statute. So by way of refresher, and I know that Dartmouth, as well as many OBGYNs and others, had concerns around this provision as well. I've taken a look at what I think is the amended language, and we still have concerns about this. So essentially what it boils down to is we never want to create a situation in which we are deterring individuals with substance use disorder from obtaining prenatal care. How we are reading this language, because it's included in the definition, is that it would subject OBGYNs as well as social workers and others to report women who have children at home who are also pregnant for abuse and neglect. The unintended consequence of that is that they may not receive the care that they want out of fear that their children are going to be taken away. It is our opinion that there is nothing within the rebuttable presumption of harm, that we're trying to figure out exactly what it is that is trying to be addressed here by including these additional definitions in the definition of neglect. Yes.
So if I may, Madam Chair. So it specifically states when the child is born. Okay, so I don't think that that affects the children at home, but I do think that a parent that is having issues with substance misuse, there is always a danger to that child. Like I said in the committee, that anytime there are drugs around, you run the risk of a child dying. I mean, I just listened to a podcast of that very same thing where the state was called on this family several times and that child was never removed and that child's dead because it got into its parents' drugs. So I don't think it's fair. I don't think this is going to stop anyone from going to prenatal. I just don't see that happening. This is when the child is born, and I think it's more important that we protect all those children.
Yep.
So, hi, for the record, Senior Director of Government Relations at Dartmouth Health. So I am reading this with both my OBs in mind and our general counsel. And our general counsel has to have reviews, policies, and procedures that our OB departments have to use. And so I have their lens in mind. I'm an attorney as well. And when I look at this, I am seeing yes, once born, right, that would trigger the referral itself. But when I am looking, if you look further down, and I'm on page, I don't think I'm on the amendment, but I'm on page 5, lines 31. And when it specifically says, unless the exposure is due to having been prescribed. So what if a mom comes to us in her 3rd trimester and she begins Suboxone or buprenorphine, but what happens for a mom who comes and it's just the 3rd trimester, but for the first 2 trimesters she was using illicit substances.
This
If I'm an OB
states when they're born, this has nothing to do during their trimester.
Right, but if I'm an OB provider, our general counsel is going to have to say, in that one circumstance, even though the child was born and mom was prescribed those medications in the 3rd trimester, that was not protected in the 1st trimester or the 2nd trimester. So this would trigger a referral. And that's where this provision is very gray and really subject to interpretation. And my conservative general counsel, with conservative lens, is going to say a referral needs to go forward.
But it states right in the language that they are monitored by a licensed healthcare provider when on this. And that's what it would be. If they, even if it came to the 3rd trimester, they would be monitored by a healthcare professional who is giving them the Suboxone.
In that one scenario, though, they weren't monitored for the first 2 trimesters.
But the child wasn't born.
It's once
It's
they are
when
monitored,
the child
though.
is born, right? And as long as they're in that 3rd trimester and they're having that, I'm never going to change from this language. And I love you guys, you know that. But I'm just not, because I think children deserve the right to be protected also.
So I think if the legislative intent is to make sure that there's a smaller window, I know Michelle would be happy to work on that. I would be happy to work on that. I hear the intent, but as I'm reading the language, there's some gray area, and I'm just concerned that I do think that I do know that there will be women who are afraid to receive prenatal care that they need.
So I'm going to respectfully disagree with you because I think the language is quite clear.
Thank you. Thank you, Madam Chair. Thank you for taking my question. So may I ask 2 questions?
Of course, yeah.
Would you be able to email us some suggested
We could work on that
language?
to try to tighten it up and make it more narrowly tailored.
I'm with Representative Rice because I think that we need to protect innocent children. But I also wanted to bring up a point that it's also an opportunity when the child is born for the mother to get support that she might not have had before. And so this provides that. And, our goal is to keep families intact. So providing support to the mother so she can keep that baby instead of, God knows what. So the baby lives. So, yeah.
You're singing our song.
Yeah.
Singing our song.
We're not in disagreement with any of this. It's truly a matter of how this is phrased and the unintended consequences that will come up of women not receiving prenatal care for really high risk pregnancies when we want to encourage them to go and receive care. We also have federal requirements. So any baby born in the state of New Hampshire right now that is exposed to substances has to have a safe plan of care as it is right now. Those resources are being coordinated. The hospital is responsible for making sure that that occurs. And there also are ways in which if a provider has concern, it's substance use plus is the standard. If there is evidence of substance use plus any concern at all that a child is at risk for not having appropriate supervision, that there may be drugs that are in the home that are not being put away, they are not having stable housing, there are things in place right now that allow for DCYF to get involved. The question that we have is why is this section necessary above and beyond what already exists in statute that provides that level of assurance, given the work that was done in 2016 and again in 2021, where we addressed this issue fairly comprehensively. I do have the legislative history because we worked on that. We actually worked on it with you, Representative Rice, Senator Long, and you, Representative DeSimone at the time. So this is something that we have talked about the negative consequences that are possible for babies being born in tents and moms not receiving prenatal care. And that is, New Futures and Dartmouth are in agreement. That is something that we want to avoid. And we do have concern with how the language is framed here, that may be an unintended consequence if we don't tighten it up.
Well, I would be really interested to hear what your, and we'll be meeting again that first Monday in March, but before then, if you could send us.
I will not be here, hopefully.
Well, yes, you will not be here, but we worked with Dr. Roy.
If I am, I'm going to be bringing in a week-old baby with me.
Dr. Roy
Yeah, I know, seriously.
Yeah, Dr. Roy extensively from Dartmouth worked on this, in this language, because this really is the definitions of what child abuse and neglect looks like. And once again, we don't want to make exceptions when we're just defining this. Now, what happens after, what happens with communication with mothers and stuff is very, very important. Now, we did have some trauma-informed language that we kind of switched that up to that we have.
And we have no issue with any other part or section of what is trying to be accomplished here.
Well, in this state, we want to be, we can't leave this out. We do have, issues in this state that this is going to be really important as far as how this goes. Right now, I actually think because we have this about monitoring, unless it's monitored by a licensed healthcare provider, which, by the way, in statutes, after talking to a federal judge, would include if they weren't there the first couple months, but then came in, at the last part of their pregnancy, because in that point we can't define. And by the way, the original, I think, bill that came out said in utero, and we would never put that in there because that's not the definition. That's not the children that we're defining at that point. But certainly that's more about the mother until they're born. So as long as, even if they've come in like within 2 weeks before they give birth, they still at that point are now under care. If anything, I would think, looking at this, in talking to women who have been in high at-risk situations, knowing that if they have a provider that's caring for them, that helps to protect them. I think this language actually would be more of a seatbelt for them wanting to get healthcare provider input, or at least talking to them, because at that point, then they're under that care.
Yeah, you just need to you have to understand that healthcare providers work for a healthcare institution that have a general counsel that's going to read this language with a really strict legal lens. And this does happen. And even with the rebuttable presumption language that we've done extensive amount of work on, there are still concerns. And I'm not asking to walk back the rebuttable presumption language, but I'm just saying that even today with that rebuttable presumption language, our providers are being placed between their patients whom they want to care for and do it really holistically and appropriately, and general counsel who are attorneys that have to look at the language of the law, only the language of the law. I also just want to note, Dr. Roy did not work with our office on this language. So the legislative history that we have in government relations is not something that Dr. Roy knows about. I don't know Dr. Roy. It's my understanding that she actually works at Elliott, which is a partner program in our child and safety protection program. So would love to meet her, but that was not done through our office.
And there were other folks within Dartmouth that were part of the group that articulated concern, including their pediatric department. So, yeah, it is something that we remain concerned about.
Great. And we would love, so I know that when you came to the hearing before, we asked for new language that would be helpful. So we would really, because we would like, obviously we have some high concerns too. So if you could get that language
Yeah,
to us in the
maybe-
next 2 weeks, that would be
Let's
fantastic.
work on that. Maybe there's a way to contemplate the safe plan of care and thread the needle in this bill. I don't know. We can look at it.
Yeah, and it would be helpful to understand from our perspective where the rebuttable presumption of harm language that's in there that covers some of these situations is falling short. Because it's something that we're not really making that connection of why it's absolutely necessary that it's repeated twice in here and where there's failures and folks falling through the gaps. Because we would certainly want to tighten that up, but we work with the recovery community all the time. We don't have an understanding or an appreciation for where that actually is occurring. What is the actual problem that we're trying to solve by adding this language in here and where the rebuttable presumption is falling short?
Hi, thank you. And thank you for taking my question. And maybe this is something that we might have, need help with, in researching, but do you have any anything that you can email to us, or maybe you know this, that would let us know the percentage of women with substance use disorders who are using while pregnant, who seek prenatal care, period, and is there any data that shows a correlation in states where they have added this into their child abuse language in law, a decrease in the amount of prenatal care for women in that population? Do you know of anything?
Yeah, I'd have to look back. Some of it might be a little bit stale, but I do recall when we were working on this in 2016 that the data in that area was fairly compelling, that there was a deterrent in women receiving prenatal care because they were scared. Yeah.
But after legislation is what you're talking about?
In states that had similar provisions, that what their impact was. And again, to Courtney's point, it has been the case, and we've been navigating this for a while. There's a presumption due to liability issues of, like, obviously when in doubt, report. And in some cases, even when it's not necessary. And that also has been a factor that we have been actively trying to work with the recovery community and providers and others to try to say, you don't have to report every single incident where mom comes in pregnant and has an active substance use disorder. But it still occurs. And I have concern that the language as drafted is just going to make that situation worse. But I think I do have some information and data back from when we originally worked on this in 2016 that I can pull for you.
We did hear testimony that day that there is already worry and concern amongst people who are using. So how does that change then? Like, if they're already concerned, that's my.
Yeah. No, yeah, it's a valid point. There is some concern. Providers are actively being educated. Like, I know Dartmouth has done a lot of work internally to try to assuage people of their practices. Hospitals have internal practices that they have been actively working with the department to try to receive education so that they're doing the right thing. But this is an added layer of confusion that, when we're trying to do that already right now, is not going to make the situation any better.
Okay. Nobody else has questions. We appreciate your time, and I'd love to see that language. I was looking for it after you were here last time. Yeah, that would be great. Thank you. You guys have time for Melissa Massio to testify one more time?
Sure.
Okay.
Yep, I do.
Okay.
Fine.
Are you okay on time?
Yeah.
Okay.
I just real quick wanted to clarify the
Yes.
background of this, because again, this bill has been out there since the fall of 2023 with this substance exposed newborn language in there. Dr. Roy was at the Elliott at that time. She is a pediatric abuse specialist, not maternal health, but we did talk to her about it. She is actually at Dartmouth Hitchcock now, though. She's been installed for a month and a half or so as the new CAP examiner there. But regardless, I think when this language was drafted and we did not pull in the maternal health folks, which we certainly should have and would love to see additional language. It was with a lot of research as to best practice around this issue. A lot of states have addressed this issue in statute and was adopting this best practice of substance exposure plus, which was just mentioned. That's what this language is. It's the exposure at birth with a carve out for appropriate medical care plus additional indicators of harm, just as you were saying, Representative Rice, because the concern is not just the exposure. We do not want every mother whose infant has an exposure at birth, could even just be to marijuana. We don't want those calls. The purpose of this language was to permit women who are under treatment for methadone or whatever, but to also require something more. And it is our understanding, and again, if there's different language out there, we'd love to see it. It shouldn't just be exposure. It's exposure plus, but it is that plus that is scary, because we have also seen infant deaths, fentanyl exposure deaths, safe sleep deaths, which increase exponentially when there's substance use in the home. And that is what we are trying to avoid. The rebuttable presumption language, I think, is different. It does not directly address substance exposed newborns in the same way that this language does. So that's why we weren't looking at them as duplicative or conflicting in any way. They're separate. So I just want to give you guys the background, certainly if there's other language out there, but we were really trying to put in clearly this best practice standard of exposure plus, which was not in our statute before. So.
Well, I think that concludes our subcommittee meeting for today, and it certainly gave us a full slate of what to talk about this next time. So we do look forward to having that language, obviously not from you, and good luck with your delivery. But we would like to have that as soon as possible, just so that we can look at that and get that going. We had mentioned a couple of times we were looking for that and had not seen it in the emails yet. So we're really looking forward to that, so we can then talk to the people who are on the ground, who are doing this kind of work, to make sure that that's something that works for them too. Yes. So this is the amendment that if you can approach, this is the amendment for that bill that I think, no, it is not a replace all. No, you'll see the sections. So yeah, please feel free to take that. And we look forward to hearing from you. Thank you everyone for being here today. It's a very important bill, and thank you members of the committee for being here.
Thank you.
It's that, yes. So the next Monday, I think that we can meet, because we have vacation and President's Day is March the 3rd, right? Is that Monday? Is that the 3rd or 4th? No, the first Monday in March. It's the 3rd. So the 3rd at 11, does that work for everyone? Yeah. And hopefully at that point we will have had some language, and we'll be talking about that, because they are looking to exec this bill on March 4th. And I certainly do not want to upend this entire work for one section. I want to make sure we have that under wraps too. Okay. Thanks.